Yep, I haven't turned it on yet. I'm waiting. Well, are you going to do it here? No. Oh, okay.
All right. Time to get started. And Susan has asked me to remind everyone, are your cell phones off? All right. The last time I did this presentation, I did it with my colleague, Jackie Rosenberger, and we took about an hour. But I'm supposed to compress it into about half an hour, so we have time for John, and his presentation. But just in case I go a little long, I have a short outline and long presentation. John says he has a short presentation, but lots of materials for you. All right. I'm going to be talking about the documents that you need and some practicalities and pitfalls. We've heard a lot this week about living wills, and I want to add one comment that I did some research yesterday, and if any of you are having trouble getting to sleep, I've got a book you can read. Pennsylvania Probate Estate and Fiduciaries Code. But one of the things that I discovered in it that was useful is if you are eligible for a do not resuscitate order, and that is that your doctor has determined you have an end-stage medical condition or you're permanently unconscious and you have a living will that you don't want CPR, etc., then the doctor can sign a do not resuscitate order and we don't need tattoos, can order a bracelet or a necklace that has that information. So that's a useful piece of information to supplement all of the tremendously helpful information Susan has provided. So we've spent much of the last week or so talking about the living will and talking to the family and about healthcare decisions. So I don't think I can add much to that, but there is a second lifetime document that is equally important. The living will deals with healthcare decisions, but you may be in a position that you can't handle your financial affairs. And if so, you need a durable power of attorney. And if you say, oh, I don't need one, well, if something does happen to you and you're incapacitated and someone needs to manage your finances, guess what? A court will appoint a guardian. Do you want to choose the person to handle your financial affairs, or do you want to let the court do it? Hopefully you would all agree that you want to make that choice. So it's an important document. And I'll be saying this here and other places. How often should you look at it? There isn't an absolute rule every 5 to 10 years, or you can be like my wife and me. Our documents were done in 2005. We need to update ours too. But the other is some radical change in circumstances is always a good opportunity to look at it. It may be fine, but look at it and make sure you don't need to do any changes. Your power of attorney and your living will, all the authority in there ends at the moment of your death. And so, of course, you need to deal with what happens after your death. There are two types of documents that do that. One is your will, and I hope all of you have a good will. You also can have a trust. I don't do a lot of inter vivos trusts. I don't think they're necessary in Pennsylvania, except in special circumstances. The other is beneficiary designations. You have an IRA, you have life insurance, or your broker may tell you you need a beneficiary designation for your investment account. And I'm going to disagree strongly with that in a minute, but those are the two types of documents, and you need to make sure they do what you want done, and you need to understand something that I've had many clients not understand, and that is changing your will does not change your beneficiary designations. I've had clients not tell me about beneficiary designations, and suddenly they die, and we find that their plan isn't what we thought it was because they didn't communicate. And so we have to keep asking clients about that. And not all clients are forthcoming in that kind of information. So again, see an attorney. Susan's referred to Katie Commons, who was a super attorney. My colleague, Jackie Rosenberger. Those are just two. There are other many qualified attorneys. The important point is see someone you're comfortable working with. Okay, what I want to do now, though, is to move on to this. Why? Mr. Joba, it is not moving forward. It's not advancing. Okay. All right, thank you. Let's see if this does it now. Yep. So, should you try to avoid probate? First, I've had many clients say, what's probate? Probate is simply the process of putting someone in place to handle your financial affairs after your death. It's called probate because most people, if you die with a will, you're presenting the will to the Register of Wills. Not you, of course. Your executor is doing that. You're presenting the will to the Register of Wills, and the Register of Wills appoints the executor named in your will. In Pennsylvania, it is an incredibly simple process. I can be in and out dealing with the Register of Wills clerk in 15 minutes. It is really very, very easy. Many financial advisors say you should avoid probate. First, what are the strategies used to avoid probate? One's joint accounts. Those of us who are married probably have many of our assets in joint names with our spouse. That's probably okay, but if it's a second marriage, you may want to think about that because you may have children from a first marriage and striking a balance there. But if it's a first marriage, that is often very common to have most assets joint. You can name beneficiaries, as I said, to receive property. You can have a revocable living trust. We're seeing a lot fewer of those now. Though one place I strongly recommend having a revocable trust is if you own non-Pennsylvania real estate. For example, property in the Jersey Shore or property in Rhode Island. I'm looking at one of our audience members who I know has a property in Rhode Island. There's a real advantage in having that titled in the name of a trust because if you don't, you have, when you die, to transfer the property, you have to go through what's called ancillary probate, which can be a little bit more complicated. So we do recommend for non-Pennsylvania real estate to put that in a trust to facilitate the transfer. But do we, and then some people will get annuities, and I'm not a big fan of annuities as an investment vehicle. They're a great way to convert capital gain into ordinary income, which usually is not the direction we want to go. So annuities are fine if what you want is a guaranteed income for a limited period. But as an investment vehicle, in my opinion, the primary beneficiary of annuities is the agent who sells them and gets the commission. So why shouldn't you put named beneficiaries? You have an investment account at Edward Jones or wherever. Why shouldn't you put those named beneficiaries and avoid probate? Well, if you have, I have three sons, And if I put all of my assets in with beneficiaries, who is going to pay the debts and expenses? Are each of the three going to be equally willing to kick back the funds to pay those debts and expenses? I'm hopeful in my case they will be, but I've had that conversation with clients, and they say, "Oh, maybe not. Maybe John won't be so willing to kick the funds back." If you have the funds going through probate, then your executor has the funds to pay those bills, and you don't have to try to manage it. And that is one of the things I spend a lot of time on, is dealing with that. We have a question.
Speak loudly.
Can't you dictate in your will that the executor is to pay all the debts and expenses and taxes?
Okay,
Repeat the
Rick
question.
is saying, can't you dictate in your will that the executors pay all the expense and taxes? Sure you can, Rick, but there's a question. If you have, the furniture is the only probate asset, what good does it do to say in the will, pay all the debts and expenses? Where does the executor get the money? The executor, whether you say it in the will or not, the executor has the duty to pay the debts and expenses. The question is, does the executor have the money to pay the debts and expenses? I almost never have a debts and expenses clauses in my will unless a client really wants them, because Pennsylvania law, and probably the law of every state, says that's the first responsibility of the executor, is to pay the debts and expenses. So, not terribly necessary. Susan, can
Is what you're saying that if I have a beneficiary on my IRA, that precedes the will?
yes,
In other words,
yeah.
so you're better off without designating?
No.
Okay.
I'm distinguishing between IRAs and general investment accounts. IRAs, there are good reasons to have a beneficiary designation. And I could talk a half hour on this topic, but the basic reason why you want a beneficiary designation on the IRA is that there are complicated minimum distribution rules that come into effect after your death, and you can get a longer period for your beneficiaries to be able to withdraw the funds from the IRA if you have a well-crafted beneficiary designation than if it goes to your estate. So that's an important difference. IRAs, it's worth it to have a beneficiary designation. Investment assets, it is not. Now, there are times that I merge those two, but let me just hear the other question. Hava.
So I guess what you're saying is, if I have named in my will beneficiaries who are supposed to read to, whether family or charities or whatever, that's separate from whatever I may have on my TIA-CREF account with the beneficiary. So you're distinguishing between those two kinds of things?
Yeah.
So if I change my will, it changes the people or institutions who are going to receive the stuff that in my will, it's.
But it will not change the beneficiaries. I assume when you're talking about TIA-CREF,
Yeah.
you can have a straight investment account with TIA-CREF, or you can have
It's a
IRAs.
It's a
Or a
retirement.
retirement account, or with TIA-CREF, it'll be a 403B account, if you haven't converted it to an IRA. Those generally are worth it. There's another reason
Okay.
why beneficiary designations are not a good substitute for a will. They're much harder to deal with unexpected situations. So I'll give you an example of what I have done in a place where you merge the two. My IRA says to my wife, if she doesn't survive me, to our 3 sons. And then it goes on to say, if one of my sons predeceases me, then his share will go to the grandchildren's trust under my will, and then my grandchildren's trust deals with the special issues that are involved when assets might be going to a minor. Now, how likely is it that one of my sons is going to predecease me while my grandchildren are a minor? Not very likely. But I had a partner whose wife was here for several years, K.O. Bragi, and his philosophy was, if I omit one possibility from my will, that's the one that will happen. Her husband was one of the best probate attorneys in Pennsylvania, and I was fortunate enough that he was one of my partners. So the point is, if you want flexibility and you want your executor to be able to manage things, you really want to avoid beneficiary designations on investment accounts. You probably want to keep them on IRAs. Oh. Choosing your executor. There's no easy choice for an executor. You want to have someone who is good at managing finances. You've thought about that when you're thinking about who you should name for your power of attorney. That's probably the right person to be your executor. That may not be the right person to make your healthcare decisions, as Susan has made quite clear. Single versus multiple, you can go on about that. Obviously, it's a little more complicated to have multiple executors, but if you have, say, 2 children, do you want to offend one by naming the other? There's just all those things that are personal dynamics you have to look at. And I have some questions here, things like, should I treat my children equally, etc. There's no easy answers to that. You simply need to think it out, talk to your attorney about it, and I would encourage you, if you are thinking about treating children unequally, not to wait to let that be a surprise to them. If you really think it's important, are you willing to tell the child who's getting the smaller share, tell them now why? If you're not, then maybe you shouldn't be naming them, treating them unequally. All right, I could go on for longer. Okay, Glenna has a question.
And I can't get the mic on, so the first question, is that what's on?
Good.
My lawyer, I'm not a trust and estates lawyer, recommended that for the decision as to whether to pull the plug on mom, I name both sons, so that one doesn't get to say to the other, you killed mom.
That's, yeah, I mean, I think that's a good suggestion. But I also have had clients come in and tell me, this child really would be reluctant to let go. I don't want to be kept alive artificially. And so I think I need to name. And though that's all of these questions, there is not a simple right answer. The best thing to do is to talk it through with your attorney, talk it through with your family, and go on from there. And okay, I've gone through this awfully quickly. I was trying to make sure I was leaving time for John, but I actually have done this more quickly than I expected. And I've noticed some people have some questions.
Hi, Tony. This is sort of my field, so I came to see how you did. But, but the one thing I did for all my knowledge in this field is that I went to a lawyer who I knew and who said, oh yeah, he can write a will. I'd had a will since my son was born, before he was born. So, but went to him, he wasn't really experienced in doing wills. I asked him ahead of time how much he would charge, and this is a number of years ago. He said $200 or $250. I said, fine. And I didn't know he didn't have experience with wills. So he writes his will, and since I'm at a bank with a large trust department, I bring it to our attorney, who goes, and me too, by the way, I had doubts. And so it took me a few more years for me to get another attorney, and it shouldn't have, but to rewrite the whole will. Also, he came back and said it's gonna be $450, and I said, no, you said $250. I didn't tell him that the will was not adequate or appropriate. So be careful when you look for an attorney, don't just go to any attorney, go to somebody who's really written trusts and estate or wills. It's just really important to get the right person.
Yeah, and as I said, there are a number of good attorneys in this area.
There's also additional certifications. You can, when you look up an attorney, in our firm, we have one of the most highly rated trust and estates lawyers in the state. And his name is Kirby Upright, and he has additional qualifications, which I guess I could recite, I wish I could recite to you, but it's not every lawyer who can do this. And even some T&E lawyers are better than others. But you're welcome to look him up, because whatever his additional credential is, that's what you should be looking for. He's in Bethlehem, so it might be too far, but he's the best there is in the business. I'm not looking to raise business for the firm, but just information, and his name is Kirby Upright. A great name for a lawyer.
Yeah, I've dealt with him, edited some articles he's written.
I just have another question then. So for somebody who doesn't have a lot of money and doesn't have very complicated trusts or doesn't have anything like that, how important is it to get somebody who is a real expert in all this stuff? And how much more is that likely to cost?
I think there are different levels. I was at I used to regularly go to the tax section annual meetings, and at one point I was at a table with someone who was rather arrogant and went around the table polling us as to what our hourly rate was, and he was very proud of the fact that his hourly rate was $1,000 an hour. He is a terrific lawyer. If you have a multi-million-dollar estate with complications, maybe you need someone like him. But I don't think Katie Commons has the certification that Glenn is referring to. I'm not sure what she's referring to. I don't. I have been very active in the Bar Association. I've given lots of speeches. People look to me as an expert on taxes in estate planning, estate administration. There are a lot of people who do this who are well qualified for your kind of situation. Katie Commons, and the Commons and Commons firm. Barbara Sharp and Rosenberger. There's a firm in right near the Germantown Cricket Club. I'm drawing a blank on their name right now. They specialize in dealing with same-sex couples. They're very good. I've worked with them. I'm sorry, I'm drawing a blank on their name. In fact, one of their partners became a judge recently. So, Mark.
I think that was just over there.
Oh, I'm sorry.
If it's not a member of the family, is there a question of compensation for an executor? For example, some percentage of the estate?
Under Pennsylvania law, an executor is entitled to reasonable compensation. If it's a family member, usually the family member will waive the compensation. It's taxable income. So that's a good reason not to take the compensation. But yes, an executor is entitled to compensation, reasonable. There's a schedule that was published in a case called Johnson that many people use to set the fees for executors and administrators based on the size estate. Glenn?
Yeah, I found the additional credential. I looked up Mr. Upright. It's the American College of Trust and Estate Counsel.
Yeah, a lot of lawyers are members of that who do a lot of sophisticated planning. At the time, I became quite active in the tax section, and at the time they had a limit of 2 to a firm, and we had about 5 or 6, excellent estates lawyers that drink a bit on the wreath where I was, and so I decided never to go for it. That is certainly a good qualification, but it's not a necessary qualification.
Anytime I've asked him for a recommendation, he gives me the list.
Right. No, it is a good source, no question. We need a microphone back there, Glenna.
Mark over here.
And then, well, while you're passing it, Mark.
Yes, last week or maybe the week before, the lawyer from PSL said, you may want to prepay your burial expenses so that we, PSL, are not able to claim those from your estate should you outlive your money. So my question is, are there other things that a person might want to think about with regard to prepaying them so that they can be confident that certain things are done that otherwise are exposed to debts?
The funeral expenses, the main thing I can, off the top of my head, I can't think of other things you'd want to prepay.
So, can you speak to a TOD, transfer on death?
That is a form of beneficiary designation that is transfer on death. It avoids probate. And again, it often doesn't deal with complicated situations. I've had clients with TOD and I say, okay, you have 2 kids and several grandkids. If one of your children dies, what happens under your TOD designation? Does the deceased child's share go to that person's children, or does it go to the other child? And, I don't know. And that's the problem with it, that the people who are asking to sign these beneficiary designations aren't used to doing estate planning, and they don't get you to focus on simple questions like that.
I have one comment. Happened in Pittsburgh, where the attorney helped draw up the will and everything was percentages. He left a lot of money to nonprofits, but by the end of doing 10%, 20%, 15%, it left very little actual cash for his widow.
Yeah, but
And they couldn't break it. I mean, even the beneficiary said, well, maybe we don't need this much money, but they had to distribute it because he had said 10% here, 20% there. Just a word of warning.
Yeah, and I mean, you obviously need to think about it carefully, but in terms of a beneficiary saying, I don't want it, one of the strategies we regularly use in estate planning is called a disclaimer, where that you haven't gotten it quite right, and so what you do is the beneficiary says, I don't want my share. Now, that only works if the alternative possibility is what the family wants. You can't, with a disclaimer, direct where it goes. But if, for example, let's say I left half of my estate to my wife and half to my children, if all 3 children disclaimed, it would go back to my wife. And if depending on how my will was written, but probably
These
would.
are all nonprofits.
Yeah, the nonprofits. Yeah, well then that you can't control. I mean, that's an issue. You've got to think through what is to be done. There is also a strategy that is available for general probate assets, but not for IRAs, and that's called electing against the will, where the spouse can say, I want at least 1/3 of the property. That's a right under Pennsylvania law. That is another way to get around it when someone goes too far. Before I take Glenna's question, Marie's question prompted me to think about one thing I had not mentioned. Many of us are fortunate enough that we do want to leave something to charity. If you have an IRA, that is the far better source for a gift to charity than your estate. Why? Distributions from your IRA, not a Roth, but from your regular IRA are taxable income. Charities don't pay income tax. So if you're thinking of leaving something to charity, It makes it more complicated sometimes to get it right, but an IRA is a great source to fund a gift to charity. Glenna?
Yeah, a reason to update your will. This happened in my family. The will said everything was to go to my wife. Then there was a divorce, and the guy died. And his first wife claimed that since the will was written when she was his wife, she was the one intended by the will, not the second wife.
I believe under Pennsylvania law that if you're divorced, unless you reaffirm it, I believe that voids the gift in the will.
It didn't in this case.
I can check that, Glenna, but there's a lot of provisions in the law that, and that. Tony?
Yeah, I'm gonna get it right. I'm trying to remember what I was gonna say.
We all have that, Tony.
All right, I'll lost it. See,
Short-term memory.
I did that to make all of you feel comfortable. Oh, wait a second, if somebody has a question, you can ask it first.
Now, I need to give some
Oh,
time to
I
John.
know, I remembered. So, all right, the one thing I think that people may need to know is that the having a lawyer who is not the executor, sometimes the lawyer is the executor, but usually having a family member who's the executor doesn't mean you don't work very closely with your lawyer. Believe me, I did. And I was the chosen child. So my brother was left out as far as executor is concerned. But it was explained to him and he understood. One of the things I did do is disclaim the fee for the executor. And I also made a point of splitting a few assets so he benefited rather than me, just because of capital gains issues, or not capital gains, it was US savings bonds. So, but that was that's something that sometimes is understandable. And you also need to know that you're not relying just on the executor's skills. I may have had some skills, but even if you don't, and you have a sibling who's organized and caring and whatever, and that person is the right person, it's okay if they handle it well.
Yeah, I have found, and I'm not trying to sell lawyers on this, but the reality is that there are enough complications and enough situations in dealing with a will. In most cases, I believe it is a mistake not to get a lawyer involved to assist in managing the estate.
Yep.
In my experience, and I've been doing this since 1970, in my experience, most estates that we handle, the lawyer does the bulk of the work. And the other common thing is that usually people hire the attorney who drafted the will. But that is not a requirement. It's the custom, but it is not the requirement. And even if that lawyer, and I have a lot of wills in my will vault at Barbershop and Rosenberger, I have to give that will up. If someone says, no, I don't want to hire you, I want to hire Katie Commons. If I were to refuse to give that will up, your next stop is a disciplinary board. I do not own that document. I'm a custodian of it for you. So, okay. There's going to be a brief break here. I think Susan is going to make some comments while we transfer microphones. Okay. Okay.
I really have nothing to say.
I don't believe that.
I think you have to help me with this.
Well, they do a mic shift.
How does this go on?
The other way.
So maybe we don't.
Like this?
Like this, and those go over your ear.
Okay.
This classroom is full, so we're over.
Okay. Testing.
This classroom
Go.
is full.
Let me get you set up.
It really is, isn't it? So we're using the simulcast. I just want to say, Ed Chidova has made life so wonderful here.
Here.
It used to be that when we had a full
Testing.
class, everybody would get a sign that said, sorry, classroom 2 is full. And if we had a Zoom that worked, you might get a recording. Well, so every time we have a class now, whether it's
Okay, that'll be all right.
one of these presentations or Village College or the Health Committee, there's going to be a recording as long as Ed is around. All right, let's do a mic check on John, and then I'm going to go back in classroom.
Testing, testing, 1, 2, 3. People can hear okay? All right.
I would like to say one thing. I'm sitting over there. Could you please be sure to hold the mic right up to your mouth when I think Glenn was having wonderful things to say that I couldn't hear.
Much better that way. You can continue to think they're wonderful.
Well, that's too bad. So, right up to your mouth.
Okay, good. Well, I wanted you to pull out of the booklet that was distributed the papers that are stapled together, and the top says executor responsibilities and consideration. There's 2 papers I want to go through very quickly, and I think probably the way to accomplish that would be for me to wait and take questions at the end so that we don't get stalled too much. I first want to say I am not a lawyer, so I'm speaking from personal experience, and you need to factor that into your understanding of what I'm presenting. But I think the kind of experiences I have had as executor or backup executor to estates, and believe me, the thing you want to be is the backup executor. The most important person in your life becomes that executor. But I've derailed here. So I wanted to emphasize that I'm not a lawyer, okay? And if I derail completely, Dan, I'm sure, will jump up and holler and say he's crazy. And Dan, you're welcome to do that. The role of the executor is to manage and wind down the deceased person's estate, resolving any debts, paying all taxes owed, distributing assets to the heirs, and filing legal paperwork. It's a lot of work. And so one of the things Dan said something about, he's been involved in settling estates, and he did the bulk of the work. And I'll tell you what happened to me with Ada's estate. That was the first time I had a sizable estate to be concerned with. I had sticker shock because I hired Ada's lawyer. Wonderful person, Roy Yaffe. He has several clients here at Cathedral Village. But my sticker shock was he was charging $450 an hour, which is less than Katie Commons is charging. So, you need to understand that level of, and so I thought, I better do as much as I can. And in retrospect, maybe that was a mistake because what I wound up getting paid was about $7.25 an hour, which is the state legal minimum. And as a result of that, Neville was asking about compensation for executors. And, what it made me think of in terms of my planning to get my papers updated and all of this, that I would probably consider giving a bequest to the executor with the understanding that they would forego the payment of the executor fee, which is taxable. So, and I think bequest gifts are taxed before they leave the estate. So that I would urge consideration of that and talk that over with the lawyer you're working with. The second thing I want to say is, just as Dan recommended, I certainly would recommend, if you wind up being the executor, that you do work with a lawyer. It's very important. It's complicated. And I couldn't have done what I had to accomplish with Otta's estate without Roy Yoffe's supervision. And I really had a very good working relationship with him. And so that was important. I wanted to stress that. There are a lot of bills that have to be paid when you leave this world. And they pile up pretty quickly. And you need access to money. Now, what happens is if you're also the power of attorney, maybe there's some things you can pay in advance while you're still power of attorney. For instance, in Otta's case, she was in the ICU and she was on a ventilator, and that was going to end. And so I tried to, Otta had pre-planned her funeral, but she had not prepaid. I recommend pre-planning and prepaying your funeral. While I was still the power of attorney, I rushed down to Kohler's funeral home on Ridge Avenue, and I said, she's going to be disconnected from a ventilator tomorrow. Let me pay you. I sort of grew up in a family where you paid your bills. You did them on time, and anyhow. So I wrote a check to pay for Otta's funeral and wrote John Cunningham, POA. And it was entirely legal for me to do that. Yet, since I signed POA and paid for your funeral, an eager beaver at the bank refused to process the check when Kohler's deposited, because I thought I still had power of attorney ability when I was dealing with the deceased person. So that's, you get shot in the foot by some people who just don't get the entire picture. So luckily, Kohler's was very. I didn't discover this till I went and looked, and the check hadn't been cashed. And I finally went down to them and said, "When are you going to cash this check? I'm, monitoring the accounts." "Oh, we didn't tell you. They wouldn't cash it. You have to write another check." And I said, "Ah." So you have to keep up on top of things like that. But you really need to have your executor be a person that you trust and confide in. There should be no secrets between you and your executor. And not only should there be no secrets, it should all be written down. And it should be written down and revised annually. Otta did that, and she was very thorough. She was good. But boy, she left out a lot of stuff. And there I was, and she was a good friend, but I didn't know to anticipate that she regularly had money withdrawn from her banking account to give to charities. I didn't know that these funds were being distributed, and I didn't have access to the banking account right away to know what was going on. It was a little bit of a mess trying to investigate and figure out how she handled all her bills. And your executor needs to know that. They need to know what your monthly bills are, who they go to, where you keep all your records, etc. They need to know all your insurances, all your investments, your investment advisor's name. And now, often, everything we do is online. And what comes with everything online? Passwords. Endless passwords. I didn't have passwords for anything that Otta had. She had a book, and they were they were there the way I keep mine. They're a mess. So part of end-of-life planning is getting organized, and not getting organized once, but revising it, and then working with the person you're going to trust to represent you after you're gone. So there are no telephones available to the executor to reach you, whether you're up or down or nowhere. You have to do all this before you leave this earth. So you want to be sure to do that. Now let me look at my list here. Just to give you an idea of the process, and Dan talked about this a little bit. you're going to be working with the Register of Wills. And, should you decide to do this on your own, one of the things is that the Register of Wills people are very cordial. They'll sit down with you and they'll work through this, and maybe spend half an hour to get you started. And so those people line up down at the Register of Wills office. If you're working with a lawyer, the lawyer calls ahead, lets them know they're coming. They have their it's called a petition. A petition for grant of letters testamentary. And boy, that's a document you need. That's it. You go in and you file the will with the Register of Wills office with this petition, and they get back to you shortly and they grant you what's called the short certificate. And that's your legal, you can do business with me card. This person really is recognized by the Register of Wills office to represent whoever it is that they're working as the executive for. So the two primary important documents you have to secure fairly quickly are the death certificate, and that's usually provided by the funeral home or by the cremation location that you're dealing with. I don't know how that happens if you've donated your body to science, but maybe it's the hospital where you die or whoever it is that ships you away. Did you want to say something, Dan?
Yeah, I can't emphasize too much how important it is to get more death certificates than you think you might need. Because they're easy to get at the time of death through the funeral director. They're a pain in the, if you try to have to order them later.
Right, that's exactly right. And the first one usually comes free if it's the funeral director. And then every additional copy, for instance, from Kohler's was $10. So I spent $100 right away. I got 10 death certificates. And I didn't use them all because some people will accept a photocopy of the death certificate. And the same thing happens with the short certificate that's issued by the Register of Wills office. It's a document, has a gold seal on it, and it looks, and I think it might have a stamp on it. It looks official. And some places will require you to turn that over, a copy of that, or some places will accept a photocopy. But Dan's exactly right. Get them up front. Even if you don't use them all. That's really worth doing. The other thing I want to tell you about in terms of working, if you're the executor and you're working with a funeral home, one of the first people that need to hear that you have gone on is the Social Security Administration. Well, I was dealing with Social Security Administration before Doge cleaned house. There are a lot fewer people working there now. And whether it's Social Security or the IRS that you're trying to deal with on the phone, you call and say, "Thank you for calling. Your call will be answered in the order in which it was received. We estimate that we'll answer your phone call in 3 hours and 25 minutes. Right? If you hang on. Some systems now say, leave your number and we'll call you back. Those are really the great ones to work with. But I swear that the funeral homes have a secret number. And they will call Social Security and make that part of their service. Be sure that you ask them to do that. Be sure you have the person who you're representing, you need their Social Security number before they die, before you have to go searching for it. It's among the critical pieces of information. You need that Social Security number. You want the funeral home to deal with Social Security. And that brings up, I just want to say the secret to the IRS if you're dealing with them, because I hope I get to taxes in just a few minutes, because even though you died, you've lived part of the year and there has to be taxes filled out. Your income taxes are due for the part of the year. in which you were living. And then the money all moves into your estate. And the estate has to file income taxes every year that's it's in existence. So, you know, you're probably involved in 3 or, God forbid, 4 tax preparations there too for whoever your regular tax person is. The thing I wanted to mention was, about contacting the IRS. The way to get through, they open up at 7 a.m. You want to be at the phone at 6:58 and starting to dial, and then redial and redial and redial till you're actually answered. Whenever I did that, I never had a wait of more than 10 or 15 minutes. Otherwise, you're going to have hour-long waits with the IRS. And it's even worse now that Doge cleaned house at the IRS too. So with regard to the banks, Ada, and trusting your executor, Ada put my name on her accounts so that the account did pass to me and I could spend money out of that account before I got the short certificate or whatever. During COVID, banks sort of moved to expecting you to make an appointment. I didn't know that. So I went into the bank expecting, to sit down with somebody and talk to, what I needed to do. And it was Wells Fargo. And they said, oh, well, you'll need to call and make an appointment. Okay. I was back on the bus, back to Cathedral Village. Time is eaten up like crazy carrying out these activities. Once you have the short certificate and you have the death certificate and you can move forward, you need to assemble the assets of the decedent. And so what I would advise, I could have stayed with Wells Fargo where Ada did her banking, but I don't know how Wells Fargo works. And again, a lot of stuff is online. So I opened up an estate account for Ada at the credit union where I do all my banking. I was familiar with how to access them online, and you should make life for yourself. Make life easy for yourself should you be in an executor position too. So in order to open up an estate account, you have to secure a employer information number, identification number, EIN. And you get that from the IRS. You have to do all this before you go to the bank. You have to come with but you can do it online at the IRS website. And so that's one of the steps in order to set up an account for the estate. And I think I want to leave this, that talks about how it gets going, but it goes on and on like that. The other key bit of information is one of the first steps of the executor, once you have the paperwork and you're allowed to act and you're opening up an account, you have to advertise the fact that the person you're representing has died in 2 newspapers. And that's something the lawyer that I worked with handled, Roy Yoffe. And you're required to announce the estate is now in existence in the Philadelphia Legal Intelligencer. And then Roy said, we always also advertise it in the Jewish Exponent because their rates are the lowest. So I pass that little bit of inside information on to you too. What that does, that advertising, that legally required advertising, starts the clock ticking for 1 year. Because what the ad says is, this person has died. If they owe you money, you have 1 year to report this to the executor. And so what does that tell you? You're not going to finish with this estate from a year from the date that the advertising begins. And you're really not going to be able to finish right away, because once you finally clear that hurdle, then you can really begin to plan to, the final legal bill, the final tax preparer's bill, the final, those kinds of things. And then The last people who get their money, at least by my recollection from what I've seen, are the heirs, the beneficiaries, because the executor has to get their fee, and all the taxes have to be paid, and so the heirs come last. So I want to leave this first sheet, which sort of gives you a chronological view of the process of being executor to an estate, and turn to the second one that says information for executors, because this is really the kind of information you have to have done if you're going to be kind to your executor, if you're going to be kind to that nephew or niece or son or daughter or good friend. You really have to pull all this information together so that it's not a mystery. And I give you a list here that's broken out first related to funerals and memorial services and things like that, and then to talking about the different kind of financial information that's needed. And again, with this, at the very bottom of that is the caution about passwords. Everyone tells you, don't write down your passwords, don't have it by your computer. In the document that you prepare, that's just as important as your will. You'll have a separate sheet of information, because the details of all these assets, that doesn't get into the will by and large. But you have to have it's sort of like a letter of transmittal. Here's how I run my financial life. Here's where you need to get your information. Here's the person to contact. Here's their phone number. Here's their email address. Here's the account number that you'll need, And because there's so much fraud in our society, be prepared to be challenged every time you go along. It's not like, hail fellow well met. No. Who are you? Show me, People are very protective about that. All right, it's 1 minute to 12. I'm going to stop there, but you have this, and the booklet that was provided courtesy of Tariq Khan, I became aware of thanks to Ann Silverman. She said, contact Tariq's office. He's got a great booklet. And so, that booklet is an attempt to help you get your information together. And that may be the vehicle you choose. But, you also, that's designed for everybody. I'd say you needed an information sheet designed for your life and how you've organized your information. And it needs to be updated annually. And with that update, you need to communicate, give another copy, a current copy, date each one. This is information for executors, 2025, then another one, 2026. Do that every year, and be sure to, at that time, sit down with your executor and review all this so that they're a little bit au courant. The first time there was one estate I bowed out of, but I remember going and getting a tour of the house, and you'll find this in this drawer, and you'll find this in that drawer. Well, it was the first time I'd been in the house, and I was never back in the house again. I thought, good God, I'll not find anything. Oh, and in that, I won't mention any names, but in that one, I checked in. I initiated a check-in annually, and I checked in annually once, and the guy said, well, I did change my will a little bit. I put a codicil in there that so-and-so could live in the house as long as he wanted to. And I said, oh, so I'm the executor and the real estate manager. That's when I bowed out. That was more than I was going to do. Anyhow, so I'm happy to stay for a few minutes and talk to people who have questions, but I know people want to get to lunch too. Thank you very much, Sherry.
Let me just make one quick comment about when someone said about the divorce. We have a provision in Pennsylvania law that says that if you divorce and your will is not changed unless you've made it clear that you want your former spouse to take part, that voids the gift to the spouse. It's right here in the Pennsylvania Probate Estates and Fiduciaries Code.
Is it true in an IRA?
No.
Beneficiary, it is not.
I'm talking about the will.
Yeah, you're talking about the will.
John,
Okay.
would you recommend that a person who's contemplating being an executor write a list of things they will want from the
Oh, I would.
Yeah.
Yeah.